All right, good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmer, and I'm the director of the Statewide Training Initiative with Florida Legal Services, but I'm kind of wearing a different hat today as the chair for the Professional Development Committee of the Public Interest Law Section, or PILS. We're excited to have you join us here today for this collaboration with the Animal Law Section, or ALS. So we have PILS and ALS, we're pals. That's what I'm calling this collaboration. So before I introduce our speaker, I do want to go through some quick housekeeping announcements. This training is being recorded. The Animal Law section is going to post this video on their YouTube page. I'm going to drop the link to their YouTube page into the chat. Make sure you subscribe to that channel. That way you get the alert when they post a video. As far as CLE, this webinar has been approved by the Florida Bar for one general and one city, county, local government law certification credit. I'll announce the CLE code towards the end of the webinar. I'll also drop the code into the chat. And I believe an email should go out automatically from Zoom with some of this information as well. And we'll make sure to include it in the description on the YouTube video. As I said, this training is being co-hosted between the Public Interest Law section and the Animal Law section of the Florida Bar. I'm going to drop links for both sections into the chat so you can check them out. Hopefully you are a member of one of them or two of both of them, but if you are not, I highly encourage you to take a look at both of these sections. They do some amazing work and they have some amazing people. And with that, Laura, I'm going to ask you to say a few words about the Animal Law section, and the floor is yours.
Happy to do so. Thanks for the introduction. Good morning, everybody, or happy lunchtime. Thanks for joining us all. We're so happy to have our friends from PILS here, and we're looking forward to the CLE today. And just a PSA, if you have not joined the Animal Law section yet, please do so. You can get joining information on our website. And also PILS, wonderful partners. Really, I've enjoyed doing this CLE partnership more so than any others. Sorry, that's my son in the background. And with that, I'll turn it back over before his questions get more interesting.
All right, this topic I know for sure is a really popular topic that triggers a lot of questions, a lot of conversations. So with the webinar, we don't have the chat enabled, but we do have the question and answers feature enabled. So feel free, if you have any questions during the webinar, post them into the Q&A feature. If the question is relevant to the slide, I'll probably interrupt Joe and I'll bring it up so we can address it right then and there. But if for whatever reason we don't get to it during the presentation, we'll open it up towards the end to make sure all of those are addressed as well. So with that said, it is my pleasure to introduce to you our speaker today, my colleague, Joe Cordova. Joe is a former Equal Justice Works Fellow. He began his legal career with community lawyering for immigrant families. He now leads Florida Legal Services Fair Housing Initiative project, enforcing housing discrimination laws through HUD-funded programs. With degrees from DePaul University, the University of Colorado, and UF Levin College of Law, he has over a decade of experience serving vulnerable communities. In 2018, he received the Helen Gibble Blackman Memorial Community Service Award. So without further ado, I'm pleased to pass it over to you, Joe. The floor is yours.
All right, terrific. Well, thank you all so much for attending, for having me, letting me be a part of this conversation. And also just a housekeeping note, I believe we have the Q&A available through, I believe it's through the Q&A option. I like when the conversation is a little bit more active and interactive. So if you drop questions in the Q&A, I know that Jorge is going to help out and keep an eye on that for me. I like to answer questions in live time, but we will have time at the end of the presentation for questions as well. So if you have a question you'd like to ask, throw it in that Q&A section and we'll do our best to answer it in live time. But if you want to hold it till the end, that's also your prerogative as well. So today we're talking about Fair Housing Act protections for DV survivors living with emotional support animals. Real quick, I'm going to zip all the way to the very end of the presentation before I jump back to it. Quick disclaimer, I want to make sure I read this. The work that provides the basis for this publication and presentation is supported under funding through the U.S. Department of Housing and Urban Development. Basically, what I am going to say is what I know to be true under the Fair Housing Act, but what I say and how I say it is not necessarily the views of the federal government. So that is the official disclaimer. And now let's get back up to the beginning of this presentation. So common housing issues that survivors face. We probably all know this, that when you're facing discrimination, especially with domestic violence, as a survivor, you're being denied access to housing quite often. The most common way this happens is, at least this is a common story that we hear, is that a couple, a household, a family, there might be some, loud noise one night, or maybe the police come by one afternoon. And, a domestic violent incident can be a standalone event, but often it is kind of the end result of a lead up. Well, what happens a lot of times is the landlord will eventually go to the household and say, last night was the final straw. I want everybody out. I'm not here to ask who is the perpetrator. I'm not here to ask who is the survivor. I just want all of you out, and I am going to allow this eviction to stand based on the idea that you are violating areas of the lease related to, nuisance. Possibly a law was broken in the household, which violates the lease. For whatever reason, evicting the entire household is often the response from housing providers and landlords. Well, when you evict the entire household now has an eviction on his or her, housing record. And so moving forward, looking for housing, getting my life back together. Maybe I spent a couple of months in a women's shelter. I've had the resources and the support I need, and it's time to get back out there. I'm being denied housing because of my eviction history. Well, even though that eviction history is not due to my own affirmatively active, behavior, I was actually on the receiving end of the abuse. I still have the eviction record nonetheless. So that is one of the more common stories when it comes to how domestic violence survivors are being discriminated against in housing. The second most common way is possibly, this is also pretty common, is if you are in a domestic violence situation and you are scared and you hide yourself in the bathroom or upstairs in the bedroom and you lock the door and you call 911. And the police arrive, the police usually talk to the first person waiting for them on the front lawn. Well, that person is most often the abuser. And so the police are often going to listen to and possibly believe the story that they hear first. So they go inside the home and they actually arrest who will eventually be known as the survivor of the domestic violence. Well, when everything gets sorted out and injunctions are put in place and no contact orders are put in place and plea deals and everything finally settles into place, sure, the survivor is not charged with domestic violence. Usually charges are dropped, but there's still an arrest record. And so a housing provider might look on this person's criminal background check and see an arrest, or they might see that charges were brought but eventually dropped. But for whatever reason, they're going to see that person's name linked to some sort of charge of battery or arrest related to domestic violence. A housing provider might use that as an excuse to deny housing. So it's not so much, I think a lot of people, when they hear domestic violence survivors are being discriminated in housing, a lot of us scratch our heads and say, who is saying I refuse to rent to survivors because they're survivors? I'm sure there are plenty, but the majority is because the domestic violent incident kind of follows, the fingerprints of that event follows the survivor. And the survivor now has to spend time explaining to new landlords and future landlords, it wasn't my fault. I'm actually the survivor of the domestic violence, and so on and so forth. So you can understand that these common housing issues will follow people throughout their life, and they always have to have this story to tell. Oftentimes, there's no access to safe housing. What we often see in our world is people will call us and say, I share a lease with my abuser, and my landlord won't let me out of the lease because of rules of joint sever liability. Both names are on that contract. And therefore, if my abuser abuses me and skips town, my name is still on the lease. Or if my abuser abuses me and says, I'm not going anywhere, we signed this contract together. What am I supposed to do? My name is on the lease. If I go seek safe housing with a family, friend, or a shelter, I'm still on the hook for this contract that I signed? So these are problems that come up quite a bit that often will lead to the survivor having no other options except for shelters and homelessness and so on and so forth. But one of the biggest ones we do hear about, and this is what the topic of today is I am a survivor of domestic violence, and part of my path forward includes a prescribed emotional support animal and maybe a similar reasonable accommodation. But we're going to talk about the support animals today. And as I move forward in my life, trying to take these bold steps forward, landlords are dismissing my housing application and denying it because I have an emotional support animal. Well, this emotional support animal isn't necessarily tied to somebody because they're a survivor. It's tied to them because they have a disability. And so what we're going to talk about is how that disability and how being a survivor definitely has some overlap. But I want to make sure that I distinguish the two from each other. So we talk about the Federal Fair Housing Act. It prohibits discrimination in housing-related transactions because of a person's protected class. I want to make sure I'm very clear. We're talking about the Federal Housing Act. So this is true in all 50 states. Every state has their own state fair housing act, and most counties and municipalities will have a local ordinance or a fair housing ordinance at the local level. Today, we're talking about the Federal Fair Housing Act, and for the most part, the Florida Fair Housing Act is one and the same with the Federal Fair Housing Act in regards to these protections. So the protections we're talking about are race, color, religion, national origin, sex, disability, and familial status. Just a couple of quick notes to make sure we understand what these protected classes are. Race and color are two different protections. Race often refers to your bloodline, your identity, your heritage, whereas color is going to be specifically the color of your skin or maybe some physical characteristics. It's also, remember, if a landlord perceives you to be a member of a particular race or color, but you're not, but because of the perception you are being discriminated against, that can still be a violation of the Fair Housing Act. You don't necessarily have to prove that you are the race that the landlord thought you were. When it comes to religion, it doesn't matter what religion you practice. It does not matter if you practice a religion or have faith at all. It is still going to be protected and cannot be used against you. One thing I want to make sure very clear, we talk about protected classes. We're talking about the nexus between who you are and whether that is being used against you to deny you housing. It's not immunity from denied housing. Regardless of your race, color, religion, disability, familial status, you still have to pay rent. You still cannot breach your lease. You still have to abide by the rules of tenancy. So it's not immunity from eviction. It's basically protection from eviction if any of these are being used against you because of your race, color, religion, national origin. And it applies to all of us because every single one of us is a race. We are all a color. We all have some sort of religion, faith, spirituality, or no spirituality, no faith that we link to. So whoever you are, we all have these protections. It does not matter. National origin is tricky. This is not the topic of the day, but just a quick note. National origin is about discriminating against somebody because they are from another country or a particular country. It does not, at the federal level, it does not protect legal status or citizenship status. So if you're denying someone housing because they do not have a lawful right to be in the United States, that is not a violation of the Fair Housing Act. The way that would come into be is, let's say I have a housing community and I accept 10 applications and 8 of those are from people from Haiti. And I deny 2 applications, also people from Haiti, but they do not have legal status. That's not going to be a violation of the Fair Housing Act because it's not the fact that you are from Haiti that led to the denial. It's the fact that you did not have legal status. Now, there's no rule that says a housing provider is not allowed to rent somebody because of their legal status. It's just that you cannot use legal status as one of the protections. Sex, I want to make sure I highlight this. As with any incoming administration, every 4 years, 8 years, we have new administration. The Fair Housing Act itself has not changed. In fact, I believe it's been over 20 years since the Fair Housing Act itself has been re-legislated and renewed and changed. But different administrations will enforce parts of the Fair Housing Act differently. Under the previous administration, sex, via the Bostock v. Clayton County case at the Supreme Court, which was an employment discrimination case, as well as Executive Order 13988, which took the legal reasoning of Bostock and put it into the Fair Housing Act. Under the previous administration, sex included sexual orientation and gender identity. But again, because the legislative branch did not change the Fair Housing Act, the new administration has withdrawn 13988 and said that sex does not include sexual orientation and gender discrimination or gender identity discrimination. So at the federal level, sex only includes discrimination based on male-female discrimination, as well as sexual harassment, which includes quid pro quo, a landlord saying, you know, you don't have to pay rent as long as you engage in some sort of romantic or sexual relationship with me, or hostile environment, where a leasing agency or any subcontractor of the housing provider is creating a hostile living environment based on sex and sexual advances. So that is how sex is now going to be enforced under the Fair Housing Act. If you live in a local ordinance or jurisdiction that specifically identifies sexual orientation and gender identity as being protected in your local area, then your local area might offer those protections. But at the federal level, sex does not include sexual orientation and gender identity discrimination. Under disability, that's what we're going to be talking about today. So I'm going to skip over disability and then real quick on family status. This is protections for families with children under the age of 18. So if you are a family trying to find housing and you go to take a tour and the landlord sees that you have kids in the back seat when you pull up and they say, suddenly it's not for rent anymore, that's a violation of Fair Housing Act, as well as giving different terms and conditions for families with children under 18. So even if a housing provider says, oh, we love children, we're going to put you guys in building C because that's closer to the playground, they might be thinking they're doing something nice, but what in fact they're doing is they're segregating families with children from other households, which is going to be a violation of the Fair Housing Act. So I want to make sure I clarify this slide as well, because the new administration is going to have some different understandings of how what this says is going to be enforced. Because the overwhelming majority of domestic violence survivors and sexual assault victims are women, they are protected by the Federal Fair Housing Act's prohibition on sex discrimination. So if I go back to that previous slide, you'll notice domestic violence survivor is not a protected class, okay? So if you want to file a complaint based on your status as a survivor, you may not have standing under the Fair Housing Act because domestic violence survivor is not a protected class. Now, traditionally, again, because statistically speaking, more women are survivors than men, this could be what's considered a violation of the Fair Housing Act under the disparate impact theory. Disparate impact being the idea that says you have a neutral policy on its face, but when implemented, it's going to impact more of a specific group of people than others. And as long as that specific group of people are members of one protected class, we might have a violation of the Fair Housing Act under the theory of disparate impact. Well, I want to make sure I highlight that between 2017 and 2021, the administration was attempting to narrow the definition and implementation of disparate impact theories. Disparate impact, I won't go too far into this right now because I want to get on to the emotional support animal discussion. But disparate impact is kind of like a tennis game. It's a tennis match of burden. Basically, it starts with the plaintiff recognizing that the neutral policy is, in fact, statistically having an evidence-based impact on a particular group of people. In order to succeed with a disparate impact claim, you have to bring forth lots and lots of statistics, regional statistics, local statistics, possibly national statistics that say a rule like this is doing more than simply denying housing to this person. It's going to deny housing to anybody who shares a protected class with this person. Then it volleys back to the housing provider, who then says we have a legitimate business reason for this policy. If you can successfully argue this legitimate business reason, it volleys back to the plaintiff, who has the burden of showing that while, yes, there may be a legitimate business reason, there is an alternative means for putting forth a policy or a rule that will lead you to your legitimate business purpose. And then if they're successful as the plaintiff, it volleys back to the defense one more time, where the housing provider gets to argue, while that may be true, this alternative solution that you've put forth will cost us too much. It will be too much of an undue burden on our side. So traditionally, disparate impact is looking at that volley back and forth of the burden shifting. Like I said, from 2017 to 2021, there was an attempt to narrow that burden shifting and make disparate impact claims more of a burden on the plaintiff's side to prove that evidence. From 2021 up until 2000, early 2025, that disparate impact kind of was widened once again. And there is a belief right now, we don't have clarity, but there is belief that disparate impact claims might go back to the attempted interpretation from 2017 to 2021. So I say that now. Obviously, I didn't give any specific clarity because I don't have any right now. But making the claim that domestic violence discrimination is a disparately impacted violation on women under the Fair Housing Act, just be aware that in order to make that claim, the burden shifting might fall heavily on the side of the plaintiff. Okay. But what I want to talk mostly about today is how domestic violence survivors may be protected under the protected class of disability. So a disability under the Fair Housing Act is defined as a physical or mental impairment that substantially limits one or more of a person's major life activities. This includes diseases. This includes drug addiction. This really includes anything that stands as an impediment to the major life activities, which are defined as things like working, sleeping, breathing, the basics of life. These are major life activities that we all have a natural right to participate in. If you have an impairment that substantially limits your ability to participate in those activities, this would be qualified as a disability under the Fair Housing Act. Similar to race and color, it also includes a record or the perception of having the disability. So if you are somebody who for the week is recovering from surgery and you're using a wheelchair and a housing provider denies you housing because they do not have the infrastructure to house you, and you're not going to be in that wheelchair longer than a week or two, but it was perceived that you had a disability and that's why you were denied housing, that might be a violation of the Fair Housing Act, even though you don't have a long-term disability. So the unlawful practices here is basically denying housing to persons because of a disability. Now, I changed this slide because the language originally said denying housing to persons with disabilities. That's not an unlawful practice. Just because you have a disability does not mean you are immune from being denied housing. If you have terrible credit, if you do not have income, so on and so forth. If you don't qualify for the housing, having a disability is not a reason to pass on the qualifications that you're supposed to be able to meet. But if you're being denied housing because of your disability, then definitely that's a violation of the Fair Housing Act. This includes anybody in the household. I know a lot of the people that come to me, I recognize that it's my husband, it's my son, it's a member of my household that has the disability. You still have standing. If you're being denied housing because someone in your household has the disability, then you are still protected under the Fair Housing Act. This includes not necessarily just denying people housing, but denying them access to the privileges of housing, which includes recreation facilities, parking privileges, and other services offered to all tenants. You cannot say yes under the condition of. As long as that condition applies to everybody, then that's fine. But if you are given different conditions because of your disability, that's a violation of the Fair Housing Act. You're not allowed to segregate people with disabilities into certain areas of the housing complex. This one is confusing. A lot of people with disabilities, physical disabilities, require first floor housing units. And so they would request as a reasonable accommodation, may I please have a unit on the first floor? However, if a housing provider preemptively says, we just put everyone with a disability on the first floor, that could be a violation of the Fair Housing Act because it's preemptive segregation. The timeline is supposed to go, I have a disability, I'm requesting a first floor unit. And the housing provider says, yes, as long as we have them, we can make that accommodation. But to preemptively say everyone with a disability belongs on the first floor, that's segregation. And then denying these reasonable modifications and accommodations is a violation of the Fair Housing Act, which is what we're going to talk about next. So a reasonable modification is a change made to the housing structure, the exterior, interior, common areas. If it's private housing, a landlord is allowed to say, yes, you can make this modification, but you have to pay for it out of your own pocket, and you have to pay to restore it back to the way it was upon your vacancy. If it's public housing, any sort of government subsidized housing, the landlord is supposed to say, yeah, I'm sorry, not any subsidized housing. There's a whole list with some asterisks and stuff like that. Traditionally, if it's private housing, the landlord says, yes, you have to pay for it. If it's public housing, yes, and the public housing provider will pay for the modification. Again, grab bars in the bathroom, lowering countertops so someone in a wheelchair can use them. I had a client once need a peephole lowered so that she could look out the peephole so that she knew who was knocking at the door. So these are situations where the landlord is supposed to say yes, as long as it's not an undue burden to the structures of the building or an undue financial burden. But in private housing, a lot of times when we help clients request these modifications, we remind them that there's no burden to you if our client is the one paying for it. All we need from you is the thumbs up, yes, this is okay to do. Now, reasonable accommodation is what we're really talking about today. So an accommodation is a change made to a rule, policy, practice, or service that is not necessarily an allowance to break the rule. It's a carve out inside of an existing rule to allow somebody with disabilities to enjoy their housing equally to others. Again, as long as it does not impose an undue financial or administrative burden, as long as that request is reasonable, it needs to be answered in the affirmative. It's not supposed to come with any additional fees or deposits. But when it comes to asking for a reasonable accommodation, we'll get into a little bit here in a sec. The landlord is allowed to ask for certain information to confirm the need, but the landlord is not supposed to play doctor and determine the need. They can simply seek information to confirm that need. Now, real quick, when we talk about changes to these rules, I know a lot of my clients in the past have been a little confused thinking, I've requested an accommodation, therefore I don't have to follow these rules. That's not true. Again, you must still follow all the rules. It's just that you have been accommodated kind of a narrow exception to a specific rule. That's what we're talking about with accommodations. We talk about assistance animals as probably the most often requested accommodation. A lot of housing providers, landlords have no pets policies, or they have pet policies that deny pets regarding to certain breeds of animals or sizes and weights of animals. If the emotional support or service animal is confirmed by a doctor as prescribed and needed, then it is no longer a pet. Please consider an emotional support animal or a service animal the same you would as a doctor prescribing medication. So just like a landlord or a housing provider would never go through your medicine cabinet and say, you can take these pills, but not these ones. You can take 30 milligrams of this, but you're not allowed to take 60 milligrams of this. That's the exact same thing of saying you can have this kind of animal, but you can't have that kind of animal. And the reality is because landlords will often try to say it's unreasonable for me to say yes to this particular dog because it violates our pet policy. All right, I know my audience. I know I'm speaking to the animal law section. I told myself I wasn't going to do this, but this is the best way to explain it. This is where I lose friends. I am a longtime vegetarian / vegan, but I'm not a pet person. I apologize ahead of time. I'm not a pet guy. So if my doctor prescribed an emotional support animal to me, I would say you've got to be out of your mind. This is going to give me more anxiety than it would ever relieve the anxiety. But if my doctor talked with me and said, I really think you would benefit from this, how about a goldfish? You can have an aquarium, you can hear the bubbles and maybe a couple of different fish. And in the mornings, you can feed your fish and it'll give you that sense of calm, that kind of different kind of take you out of the moment situation that we need. And you're going to really benefit from this interaction with these fish. And I take a deep breath and I nod my head and I say, okay, that sounds good. I'll do that. If I move into a housing provider that says, sorry, we don't allow for aquariums, but you're allowed to have a cat, that cat isn't doing anything for my disability. It's not doing anything for my mental health. If anything, Joe plus cats is more anxiety, okay? It's more PTSD. So an emotional support animal is prescribed by the doctor based on the patient's needs. A lot of landlords try to get in the middle of that conversation and say, well, I don't understand why you have to have 2 dogs. Why can't you just have 1 cat? It's not emotional support general animal. It's emotional support animal that serves my needs. And I remind this of housing providers all the time. Now, if they're saying my emotional support animal is a shark and I need to install a shark tank in my studio bedroom apartment, this could be considered an unreasonable accommodation request because the plumbing and the size and all that kind of stuff might be, a situation. What if my emotional support animal is a 15-foot long alligator that serves an actual threat to my neighbors in my neighborhood? Again, that might be an unreasonable request. But as long as the animal that is providing that emotional support is reasonable, the landlord is not supposed to stand in the way of why you do or do not need it or trying to offer alternatives and stuff like that. Keep in mind, the key word is reasonable versus unreasonable. So under the Fair Housing Act, there are 2 types of assistance animals. Service animal, which is trained and certified and is trained to perform a specific task. Under the definition of service animals, we're talking about dogs or miniature horses. But in the world of emotional support animals, these are not trained or certified, and they provide therapeutic emotional support. And they can be a variety of animals. I know we have a picture there of a gentleman holding an alligator. If that alligator is still a baby or it's going to be, kept in a safe space, there might be a need to approve that accommodation request. I think this alligator that this gentleman's holding might be a little bit too big to be considered reasonable and safe and stuff like that. But for the most part, we're talking about reasonability and safety. That's what housing providers are supposed to be looking at. They're not supposed to be looking at whether or not it makes sense to them. It's just a matter of reasonability and safety. So the proper request and approval process goes like this. The tenant makes a written request for an emotional support or service animal to be allowed in the housing. I always advise, please put this in writing. Now, HUD guidance has said that a verbal request qualifies as putting the housing provider on notice that they need an accommodation, but it is always best to have the timeline include a written request for an accommodation. And that written request for an accommodation basically needs to say, I am a tenant or I am a prospective tenant. I require an emotional support animal or service animal, and I am making this request under the protection of law of the Fair Housing Act to be allowed an accommodation to your pet policy so that I may live with my service animal or emotional support animal. It does not have to say this is the details of my disability. This does not need to say here's why I need it. It does not need to say here's what it does for me. It just needs to recognize this is my request and I am submitting it to you. Now, along with that request needs to come a doctor or a qualified professional's letter confirming the need for that emotional support or service animal. So when we help clients, we draft the request letter and we get the doctor to request a second letter that confirms the medical need of the emotional support or service animal. Again, it doesn't have to go into the weeds of the disability, but it does need to confirm the need. So as long as the tenant is comfortable with the doctor just simply saying the bare bones basics of it is in my medical professional opinion that my client would benefit from an emotional support animal to provide therapy for, and this is where you might need to say something like, extreme anxiety, PTSD, or something like that. It doesn't need to go into any details. It's just enough to show the housing provider that this is a legitimate medical need confirmed by a doctor. Now, I want to pause there because there's underneath the Fair Housing Act and HUD guidance, qualified professional letter can be used. I have reached out to a lot of housing providers. I've done a lot of presentations to landlords, leasing agencies, and stuff like that. I also had a great meeting once with the people at petscreening.com. For those of you who don't know, petscreening.com is a third-party organization that a lot of housing providers will contract out their reasonable accommodation requests so that they don't do those approvals in-house. They farm them out to petscreening.com, who will then review the doctor's letters and all the kind of stuff that's being asked for to come up with a recommendation to the housing provider whether or not they should or should not approve the accommodation request for an emotional support animal. And I have asked pets, first of all, a housing provider cannot force a tenant to go through petscreening.com. As we just got done saying on this slide, you got your own letter that makes the request and the doctor's letter confirming it. If the housing provider says, great, thanks, send this off to petscreening.com, the tenant has the right to say, I don't think so. The Fair Housing Act tells me to provide you with these two documents, these two letters. I've done so. If you want to send my stuff to petscreening.com, you're welcome to do so for you, however you make your decision. But you cannot give the tenant extra legwork. The only thing that the tenant has to do is provide you with the request and the doctor's letter confirming it. And if it's not a doctor's letter confirming it, it can be any sort of medical record that provides evidence that you need it. The doctor's letter is best because the doctor is the one making the prescription, the advising the client to have this emotional support animal. Anyways, I was talking to petscreening.com and I asked them, do you guys allow letters from women's shelters? It's not a doctor, it's not a therapist, it's not a psychologist, but it is somebody high ranking at a women's shelter who has spent the last couple weeks, couple months with the survivor and recognizes that in order to move out and move into an independent lifestyle, an emotional support animal is best. Now, the women's shelter is not in a position to prescribe an emotional support animal, but sometimes women's shelters will provide a letter saying, we have been working with this person for a long time, and we believe an emotional support animal is part of their path towards independence. Petscreening.com has kind of smiled and nodded their head and said, when we get these letters, we often tell the housing provider, go ahead and accept that. You don't need to make this person relive the trauma of going back to the doctor and getting the letters and getting the police reports, and all that kind of stuff. If they've spent time at a women's shelter, there's probably a good reason why an emotional support animal is needed. Having said that, a housing provider does not have to accept a letter from a women's shelter. We are on the crusade of encouraging them to do so, but they are not mandated to accept a letter from a women's shelter. Now, if that women's shelter has in-house therapist, psychologist, or something like that who writes that letter, okay, now you got all those initials after their name, and they signed the letter and they said it is in my patient's best interest, or medical need that they need this emotional support animal. Okay, now we're back to a qualified letter. So keep that in mind on behalf of domestic violence survivors. I've often asked clients, can you get a letter from your doctor? And, they'll say something that says, I've been living in a women's shelter for the last, year of my life. In fact, I came here from Texas because that's where my abuser was. So I sought refuge in another state, and I've been living in a women's shelter. I can't go get a doctor's letter real quick. That's not a part of who I am, but I could probably get, my advocate at the women's shelter to write me a letter. I'll often say, well, go ahead, let's get that letter and let's see what the housing provider says. If the housing provider says, sorry, we need the doctor's letter, that's their prerogative. At least we tried. So it's something to kind of keep in mind and keep in your back pocket. And honestly, as attorneys and advocates for our clients, sometimes we'll do a kind pushback and say, we understand this women's shelter letter might not suffice what the law requires, but can you please look into your policies and recognize that this letter is serving the same purpose as, a qualified medical professional and stuff like that. So we've advocated on behalf of survivors, and we've had some success. That doesn't mean we've always had success, but that conversation has occurred. Now, keep in mind the letter needs to meet the nexus between the disability and the purpose of the animal. You can't just simply say, my client suffers from being in a wheelchair, and that's why they need, 7 small pigs. I don't know what the nexus is there. There has to be some sort of nexus. Now, keep in mind, an emotional support animal, the nexus is providing therapeutic assistance. So the doctor's letter needs to confirm that my patient needs therapeutic assistance. That's the nexus there. I like to throw this out there. I know this isn't a example of emotional support, but I often use this example for housing providers, and it kind of gives them that aha moment. Because a lot of landlords and housing providers really want to play doctor. They really want to ask put their hands on their hips and say, well, how does that cat actually provide you emotional support in the first place? Or how does having these 2 dogs actually help with your PTSD? Well, it's not up to the landlord to ask those questions or to understand it. The example I often give is, imagine you have a tenant who requires a reserved parking space. So a parking space that's closer to their unit. And the housing provider says, sorry, we don't do reserved parking spaces, but you're allowed to use our handicap parking. Or maybe they say, sure, we'll give you a reserved parking space. You can have one close to your unit. And then a week or 2 later, the housing provider revokes it and says, you know what, we saw you out running the other day. You're jogging, you're very active. In fact, we overheard you're training for a marathon. You don't need a closer parking space. Well, what they don't know is that that person was assaulted in a parking lot. And the PTSD stems from having to walk through parking lots late at night. So if I can have a closer parking space to my unit, and when I get home at work, I don't have to walk through a parking lot, that's the accommodation that I'm looking for. It's not a physical accommodation. It is a emotional mental health accommodation. And so a closer parking space for me might mean something different than a closer parking space for you. Just like having an emotional support dog might mean something different for me than what an emotional support cat might mean for somebody else. So again, if you ever get pushback from landlords saying, I don't understand the nexus, as long as there is a nexus, they don't have to understand the details of it. They just have to understand that it does exist. All right, so here comes a little case scenario. I'm curious what people's responses are. So if you're able to access the chat or the Q&A, please feel free to dive in. So Terry has PTSD and delivers a doctor's note to her property manager seeking approval for having an emotional support animal in her apartment. The doctor she met with was an online therapist with full credentials whom she has met with twice. The animal she selects is a non-venomous snake, 3 feet in length and roughly similar in size to her arm, named Jake. The snake reminds her of one similar to the one her cousin had when they were kids and takes her back to a peaceful part of her life when the snake wraps around her shoulders as she watches TV. The property manager refuses the request, stating that it will make the other tenants uncomfortable and that their pet policy is very strict. Okay, so what do we think? Is this a violation of the Fair Housing Act? How would we advise our client, and how would we advise the housing provider to do the right thing here? I know we're not necessarily, I don't think microphones can come on, but if you have access to the Q&A or the chat, please feel free to throw some thoughts in there. Let's see what we have. The snake is not a pet, so the pet policy doesn't apply. That's correct. That snake is not a pet. I think it is a violation. Okay. Yes, it is a violation. What about the part where the landlord says, I'm sorry, this is making other tenants uncomfortable? We specifically use that language. It's making other tenants uncomfortable. The tenants are going to see it. I don't think it's big enough. There you go. Yeah. Remember, it's not standard. It's not common. We're not used to a snake. Snakes give me the creeps. Well, we live in a society. There we go. We live in a society and we share space with other humans. And sometimes those other humans chew their food too loudly. Sometimes they talk too loudly in movies. Sometimes they merge into our lane without a signal. Okay. Well, sometimes they have snakes. As long as it's not a safety issue, as long as it's not an actual threat, this is not an unreasonable request. Remember, it says it is a non-venomous snake. Okay. And it's only 3 feet in length, roughly the size of her arm. As long as she keeps the snake, well kept, just as she would any other animal. Now, remember, just because it's not a pet, it still has to abide by the lease. just because it's an emotional support animal doesn't mean a dog gets to, run wild through the hallways and bark at everybody and, make a mess on the stairs and stuff like that. No, you still have to clean up after your emotional support animal. You still have to be a responsible tenant. So same here. If Terry allows the snake to be loose in the community, that might not be a responsible thing to do and a violation of the lease in regards to things like irresponsibility and nuisance. But there's not a safety issue. And therefore, the accommodation is a reasonable request. Now, what if the landlord were to say, why does it have to be a snake? It's giving everyone the creeps. Well, it has to be a snake because that's the thing that gives her the support. It takes her back to a point in her childhood where she felt safe. That's what we're after. That's the point of the prescription. You don't prescribe medication to serve something other than what's been diagnosed. That's why the snake is important. I see a question here from Stephanie. What about if the landlord has many tenants who say they will move? Is the financial loss an undue burden? The landlord would really have to prove that. Okay, every time I approve a snake, there's a mass exodus from my tenants. Now we have a legitimate business reason to deny snakes. Okay, that's a great question. I haven't heard that before. I think the landlord can't come to the table and say, I have a lot of tenants threatening to leave if they know that there's a snake in the community. You would have to show it's actually led to a financial loss or something like that. Not to mention, if I lose 8 tenants and I put up, a new, place for rent and someone rents it, I'm going to have to show a cycle of everybody who rents the units around Terry, they never serve their lease and it ends up costing me and stuff like that. Because I love the question. One of the things we often remind housing providers is when housing providers come back and say, well, now we're going to have to look for new tenants. The reason why that's not an undue burden is that's their job in the first place. They're in the business of seeking new tenants. They have an entire office called the leasing agency in order to do exactly that. So we're not requesting the landlord to do something that's out of the ordinary practice of their business. Tenants come and go for a variety of reasons. Now, if you can say 20 left because of this snake, and I know for a fact because they told me, you might have a legitimate business reason to respond to denials of snakes. I haven't heard that come up before. That would be an interesting case study if it ever did. But I do love the question. It does put the burden on the housing provider to prove that's the reason. Keep in mind the discomfort of other tenants is not a safety issue. It might be something you mitigate as a housing provider. You might be able to say, absolutely, we welcome your snake. We just want to make sure all of our tenants feel comfortable. So please make sure you're a responsible tenant. And then you have a conversation with the other tenant saying, I'm not able to disclose why there's a snake, but under protection of law, there will be a snake in unit 4B. So that's that. We see another question here. If the emotional support animal is getting loose, not being properly cared for, causing damage to rental unit, can the landlord then force the renter to get rid of it? Yes. Actual threat, actual damage? Yes. Perceived threat? No. So that's why you can't say, my cousin once got bit by a pit bull, therefore I don't allow all pit bulls. That's animal, not racism, animalism. That's animal speciesism. It's animal stereotypes. You're not allowed to stereotype one animal simply because you or your cousin or a friend of yours had a bad experience with that animal. If that animal is an actual threat, then yes, you can say the damage is done. You can remove that animal now because it's a violation of your lease. Now, this is the hardest part for landlords, though. A lot of housing providers will push back on this and say, so you're saying I have to wait until the dog bites somebody before I can remove them? Well, you don't have to wait that far, but if the dog truly is a nuisance in the community, you can go ahead and make a decision at that point. Not because dogs are nuisance, but because that specific dog is a nuisance. That's when you're allowed to stand up as a housing provider and say, it's time to mitigate this situation, which might include the removal of the animal. This is quite common. A lot of housing providers will approve an emotional support animal, and then they're constantly looking over the shoulders of the tenant, waiting for that first mistake to hurry and get rid of the animal. We often, ask tenants to provide us a timeline of events. Do you know of any other tenants that had their non-emotional support animal pet removed for the similar incidents or something like that? So just because you've gotten the approval doesn't mean it's easy sailing from then on out. A lot of housing providers, keep their eye on you when they're not supposed to, but they do. Great questions. And then real quick about here, there's a little note about here, met with an online therapist. A lot of landlords and housing providers deny emotional support animal requests because they think they're phony. They think that they went online and they paid $75 and they got someone to write them a letter. Does that happen? Absolutely. This is America. If there's money to be made in one sort of scheme or scam, someone's on it. Don't worry about it. We've got someone on it. Okay. That's just kind of the world we live in. So if there's a way to convince people that I'll charge you 75 bucks and I'll write you that letter, people are doing it. It's not in the amount that I think housing providers think it is. Housing providers will look at any letter and say, this looks like a fake. That's just not how it works. An online therapist is a therapist. During COVID, all of us met with online therapists. Not any of us were allowed to visit in person with our therapists. So that's just kind of the world we live in as well. So a lot of housing providers push back and say, that's not your real doctor. You just met with them one time online and they wrote you a letter. What I often tell the housing provider, here's what you're allowed to do. And this is totally within the law. Call the number at the top of the letterhead of that doctor's letter. So the doctor's letter needs to be on letterhead and it needs to be signed by the doctor. Call the office and simply say, I have a letter from this person. Can you confirm that this letter came from your office and that this person is your patient? Or not even that last part. Can you confirm that this letter is derivative of your office? And the doctor's office says, yes, that is our letter. We wrote that. There you have it. It's not a fake. A lot of housing providers try to say, that's fake, give me another one. That's fake, give me another one. If you think it's fake, you have to prove it's fake. You have to do the legwork to say, this is why we think it's fake. We called the office and they've never heard of you. You know, that number doesn't even go to a doctor's office or something like that. That's how you know it's fake. So a lot of pushback from who your doctor actually is and who wrote this letter. Okay, real quick, I know we're running out of time and I want to make sure I have plenty of time for questions. I think we've already talked about this. This is really the landlord is only allowed to confirm that letter, and enough is enough. You're not supposed to go into the details of the disability. We've definitely talked about this here. A particular case I'll just kind of point your attention to, a really great case in the 11th Circuit is the Bogota versus Altamont Heights Condo Association. This was a very specific emotional support animal linked to somebody who has PTSD that was originally denied. One of the things I want to point out here on the case notes, number one, the association constructively denied the resident's requested accommodation. How did they constructively deny it? Because they just wouldn't respond. This happens in our world all the time. We send letters on behalf of clients. Would you please approve this request, this accommodation? And we just don't get a response. And then we send a second letter, you know, a week or two later. I'm not sure if you've got our first letter, but this time, please respond by this date. We just don't get a response. Eventually, we have to file complaints with HUD or with the Florida Commission on Human Relations. Under the Fair Housing Act, you have 1 year to file a complaint. You have 2 years to file a civil suit. So you want to make sure that these the timeline of your requested accommodations are clearly tracked, because a constructive denial in the form of a failed response qualifies as an undue denial or an undue delay. So I definitely, I'll go back to this slide in case people didn't get a chance to write down the citation, but it's that Bogota v. Altamonte Heights Condo Association. That is a fantastic case here in the 11th Circuit that will kind of depend on a lot when we send out letters and request letters and demand letters to housing providers to remind them that the law has spoken when it comes to the Fair Housing Act. Okay, well, I know we're getting close to the time, but I want to make sure I open it up to questions, and I thank you all for your time. So it looks like the chat is open if you have questions. Jorge's here.
I don't see any questions pending in the Q&A. Most of them were posted in the chat. We enabled it. I did drop a link to the material, so the slides are going to be there in that link. You're going to be able to access them. And here's the CLE code just in case, 8869. I'm going to drop it here into the chat as well, just in case. But let's see, I don't see any questions. So this is the time to ask questions if you have any. Otherwise, I guess we're probably
Throw
gonna
this
be
up there too, as long as my screen is. Yeah, there's my email address. You're always welcome to send a question my way. always happy to answer questions along the way and everything like that.
All right, so I guess if we don't have any questions, that brings us to an end for today's webinar. On behalf of the Public Interest Law section and the Animal Law section, Joe, I want to thank you for coming in today and sharing your expertise. So thank you for sharing your contact information. I'm sure, you know, I can vouch for Joe. He's really responsive, so make sure to email him. And thank you again for coming, and thank you everybody for joining us. Have a great rest of your day.
Thank you all. Thanks everybody. Appreciate it.